if you'd like a little extra time beyond September 23rd, that's fine, as long as there's sufficient time for response and reply. I appreciate this is a heavy lift for all of you. I will need enough time to be able to read everything, obviously, but I'm okay with that. So would, how about if, would October 9th make sense, trying to use similar dates when we can? Does the state have any problem if October 9th give you to maybe the beginning of November to respond? Or maybe it needs to be a little earlier, make sure you have enough time.
Judge Nick Klingerman, that was going to be my point. That puts a reply off until early November then. So I don't know, October 2nd. I don't know if 1 week makes a difference.
Okay, I'm just going to set it at October 1st. And then when do you think would your response by?
Give me 1 minute, Your Honor.
1 minute to respond, that's pretty good.
So would the 22nd work then? Then that would put the reply somewhere probably early November. That would give you roughly 3 weeks to review the motions at that point.
Okay. So we'll make, would November 7th be okay for the reply on that? The 12-9 motion we're talking about. Here's what I've got. October 1st for the motion, October 22nd for the response, November 7th for the reply. Not hearing any objection, so we'll use that. What else is there?
Judge, in the ultimate ministerial issue, I'm sorry, Stephen Binhack for Tyler Boyer. In the ultimate ministerial, we've seen a number of motions for extension of page limits. I suggest, if it's okay with the court, that we have a blanket rule for the case that if it's 25 pages or less, you don't have to move, and then if 25 pages or more, you would still have to move. That might eliminate some paper and some ministerial action on your behalf. So I move to change the rule in this case for so long as the motion is 25 pages or less, there would be no need for any defendant or the state to make a motion for additional page limits.
Okay. Anybody have any objection to that becoming the presumptive page limit? Not hearing any objection. So the page limit for all pleadings would be 25 pages or an extension granted. Thank you, counsel. There also are a number of motions for joinder that have been filed, or notice of joinder, I should say. As I've been reading some of these, it's pretty clear what applies to more people and what applies either to a smaller group or only to one person. But the only thing I would ask is, and I normally like to reduce paper, but if you're going to join in a specific motion when there are 6 or 7, can you file the notice of joinder on each separate one? Because that took a pretty good extra amount of time of going through one where there was joinder in 5 different motions and then figuring out who was joining in which. So that's just a request, if you wouldn't mind. If you're joining in a motion, just do it on a single issue joinder. And it's not a motion, it's just a notice. The other thing I will say about the joinder is there were a couple that were joined where there was a notice of joinder, but some of the arguments clearly had no application to the people who joined. So if you're joining in part of a motion or part of a response, if you could just identify, not setting forth the whole argument, but which part you're joining in. Because there was one motion filed by Mr. Lehman that had to do with what occurred on December 14th. That part didn't apply to certain people who joined, but I had to come to that conclusion as opposed to understanding where the joinder was. If it's just a general joinder, they're asking for it, so I'm joining in. I appreciate that you may want to do that, and then just go ahead and indicate that. Well, I'm joining just in case if you're inclined to grant it for him, grant it for us too. But that doesn't help me to understand what you're joining in. So if you could identify the issues or the topics covered in there, that would help a lot. there anything else on pure process that we need to address that I inadvertently did? Yes.
I'm not going to be here later, so I'll do this now. You've been referring to the anti-SLAPP motion, but in 2022, the legislature changed that, removing lawsuit and entering the word action. So from here on out, I think we should be referring to these as anti-SAP.
Anti-SAP, okay.
Thank you.
Thank you for that contribution. I most appreciate it. I could call it the 752 motion, and we can call it anything we like, but I will try my best to refer to it as the anti-SAP motion. Thank you.
Judge Colonel, on behalf of Mr. Roman, just check it on your last dates, Judge, because I take bad notes. The 10-1 deadlines for the 12.9 remand motion, does that also move the Rule 16 motion that was referenced by Mr. Bailey? Rule 16 motions?
Yes.
Thank you.
But I guess I want to, some of you have never appeared in front of me, haven't worked with me, others I know quite well. My job is to facilitate your efforts to do your job. So if there's something I can do to help in that regard, I am happy to do it. That could include if there's some question or an issue that just needs a discussion. You can contact my office and my JA will set up a quick virtual something. Of course, you're all welcome to come here, but whatever would best facilitate it for us to deal with those kinds of matters as they come up. So if in case that got missed, for example, and you realize that next week, let me help in whatever way I can to allow you to do what you have to do. Or anything else by way of process, counsel?
Your Honor, Mike Colombo on behalf of Jake Hoffman. I think we still have a straggling motion to extend the page length on our anti-SLAPP reply.
Anti-SAP.
Anti-SAP.
Well, Mr. Jones has just declared it.
Do I have to? Do I have to? And I believe we also have a pending motion to admit my colleague Gerald Urbanik pro hoc vice.
Okay, I'm going to grant that motion. I thought I had granted all the pro hoc vice motions. If I missed that one, I'm granting that now. And then the page limit, is it beyond 25 pages?
I think we're at 23. 23, yeah.
Okay, so that's now granted under this new provision here. I remember taking a law school exam where I didn't read the instructions, and I think you were limited to 10 pages, and I wrote 11, and the professor informed me he just didn't read the 11th page. That didn't work out well. So if it's 26, I promise you I'm not going to follow that. Let's not take advantage of it, but I'll read what you submit within reason. Okay. Procedurally, did I miss anything? Not hearing anything. Okay. The protective order seems to apply to everyone, that motion, or most everyone.
Judge, before we move on,
Yeah.
I think there was, for the record, you had sought to have a verbal confirmation from two of the defendants appearing remotely that they were both muted. I think Mr. Lehman, Mr. Epstein. I don't know if you would like to come back to that first.
Mr. Lehman, have you been able to figure out how to unmute there?
Your Honor, it seems like he's having a problem there. I don't know what it is, but
Yeah.
this is Dennis Wolinchak on behalf of Mr. Lehman. His date of birth is March 28th, 1956, and I'll avow that he is present and is hearing everything.
And I do see him there in his attempts to answer the question. Who was the remaining person that we had trouble? Mr. Epstein.
Your Honor, this is Boris Epstein, August 14, 1982.
Thank you, sir. All right, you've taken care of that.
Thank you, Your Honor.
And I assume, Mr. Epstein, you've heard everything that we've been covering?
Absolutely, Your Honor. Yes, thank you so much.
Okay, and Mr. Lehman, you could do it by a nod of the head. You've heard everything that we've been covering? You got thumbs up, good. Thank you, everybody. Anything else procedurally? Okay. The motion for protective order, let me, if it's okay to cover that next unless someone has a different preference. If not, then it's the state's motion and you may proceed. What was that? I'm sorry.
And Daniel Electors on behalf of Robert Smith Family. If you're going to get into the motion stuff now and may those not involved, please be excused.
Yeah, are there any motions that are left that do involve your client? Okay. Anybody else in the same situation?
Richard Jones for Gregory Saves It.
Okay. And anyone else? All right, so may those parties and counsel be allowed to depart? Anybody have any problem? All right, thank you all, the three of you. Yeah, Mr. Montgomery, thank you, sir. You're free to stay on if you'd like to, but your part of the hearing is concluded. Okay. Is there anyone who's remaining that the motion for protective order does not apply to? Okay. All right, counsel, you may proceed.
Thank you, Krista Wood, on behalf of the state. The state has moved for a protective order of the grand jury proceedings as well as the exhibits based on Rule 15.5 and ARS 21411A. There are several bases for extraordinary circumstances to grant this protective order. Specifically, there have been leaks in this particular case of the grand jury proceedings in several media outlets. Also, similarly situated grand jurors in Georgia, there was leaks and they faced harassing communications. Given the number of defendants and defense counsel, there's a larger probability of that type of information being leaked. And because of the leaks that have been ongoing, the protective order is warranted. The defendants are still able to review the information with their defense teams. The defense teams are able to have that information and review it. The only information that has been redacted are the grand jurors' names, and defense counsel are still able to obtain that information through the court clerk to further any arguments they have. This is only a basis to protect the grand jurors of this proceeding and to protect the proceedings as required and dictated in Arizona state law.
Great, thank you. And those who stand in opposition, if you could sequentially approach the podium and make your argument.
Good morning, Your Honor. Ann Chapman on behalf of Mr. Meadows. Your Honor, I thought that we had clarified by this time of the state's reply that Rule 15.5 does not apply in terms of limiting a defendant's access to grand jury materials. The defendant's entitled to those materials, and Mr. Meadows is entitled to those materials under both the statute, the criminal rule, and the Arizona and U.S. constitutions. I think it sounds like we agree that the extraordinary circumstances test is the test to determine whether or not the state has demonstrated that. That's the only basis upon which the court can limit access, a defendant's access to grand jury materials. And I think that the purported reasons that you've just heard are on their face not extraordinary. The fact that there are multiple defendants in a case is a choice the state made in determining how many people to charge. The leaks that the state has pointed out occurred prior to them filing the motion, as you know, and also occurred about information that Mr. Meadows and his counsel certainly had no information about. If you look at the information that was in the leaks, those leaks were clearly disclosed by the state or by the grand jurors themselves. It was information not known to the defendants, certainly not known to Mr. Meadows, and the state's made no effort to demonstrate that those leaks were made by any defendant. The state cites to a single news article indicating that there was some issue in some other case in Georgia. That, Your Honor, again, there's no evidence that they've presented that that's likely to happen here. There's no evidence that it has happened here, despite the fact that unredacted transcripts were provided to defense counsel before the state filed its motion. And there's no evidence that defense counsel made leaks in that other case in another place. Your Honor, the grand jury materials in this case involve over 20 days of testimony and over 30 exhibits. And the state's limitations requested have the exhibits and the transcripts limited to defense counsel office. As Your Honor knows from the hearing today, there are several defendants who live out of state. This limitation and this burden of having defendants have to travel from out of state to defense counsel's office is not an appropriate limitation. particularly where there's been no showing of extraordinary circumstances. Mr. Meadows has a due process right to participate in his defense, to see the evidence that the state presented against him, and to challenge that on a due process basis. And the limitations that the state has proposed are not appropriate limitations on his ability and right to do that, and have not been justified by any showing of circumstances. It's not extraordinary to have multiple defendants. It's not extraordinary to have public interest in a case, and it's not extraordinary for there to be leaks. But it would be extraordinary to say that those leaks are the result of defense counsel's conduct, or potentially the result of defense counsel's conduct, without any evidence to support that.
What about the jurors' names? What's the grand jurors' names? What's the constitutional implication of not allowing that information?
Your Honor, we provided in our materials, there is, I think, case law in support of the idea that you do need to be aware of who the grand jurors are. That allows you to challenge in part what happened in that proceeding. I think in this case, Your Honor, if Your Honor was to redact the grand jurors' names from the transcript or provide that would be appropriate in terms of providing that to defendants. That would be acceptable and appropriate. But the other limitations in terms of requiring defendants to travel to defense counsel's office to see the exhibits and see the transcripts, that would not be appropriate. But certainly defense counsel needs access to those grand juror names to research that information and make the appropriate arguments under 12.2 and 12.9, Your Honor. And just while I have, Your Honor, because it's relevant to this argument, the state has provided the transcripts and the exhibits, but they have not provided an accurate copy of one of the exhibits. I notified the state of that over a month ago, and would like Your Honor to address that with them to the extent we're setting dates and deadlines and otherwise today.
Can you, without getting into the specifics, give me an idea of what this exhibit is?
It's Exhibit 5. It's a PowerPoint, Your Honor.
And you did not get a complete version, is that what you're saying?
I got a version that was not presented to the grand jury, and I did not get the version that was presented to the grand jury, Your Honor.
Thank you.
Thank you.
Lacey Cooper representing Jim Lehman. Your Honor, we joined in Ms. Chapman's very well-written motion. I just want to point out that Mr. Lehman also resides out of state, so this is a tremendous burden for him to have to travel to our office to review transcripts. We're happy to provide him only with the transcripts that don't have the grand jurors' names, if that's a restriction that the court wants to place on those transcripts. And we would also be willing to only refer to the proceedings and the transcripts that don't include references to the grand jurors' names, except perhaps in a sealed document if that's necessary in order to file a proper 12.9 motion. But we do want to be able, Your Honor, in order to make a fulsome motion for remand, be able to make references to the grand jury proceedings and what occurred therein, and make quotes, to the proceedings, as the state has done in one of their responses. Thank you.
Ashley Adams on behalf of Dr. Eastman. I just wanted to give the court a little perspective. My client did come to the office one day to review the grand jury materials, and he was there all day and only got through about a quarter of the material. It's not just 30 exhibits. Some of those exhibits have hundreds of pages. And so it's just a lot of material. And I would suspect each of the defendants who live out of state would have to come in maybe 4 or 5 times to get through all that material. So I agree it's very onerous and it violates due process, Your Honor.
Thank you.
Good morning, Your Honor. Mark Williams from Mr. Giuliani. As you know, Your Honor, my client resides out of state, and so I would join in the opposition to the state's motion for the protective order. It's, I think, not appropriate. I need to be able to discuss this with my client, and it's not reasonable that he would have to come to my office in Nogales, Arizona. We'd be honored to have him there, of course, but it's not appropriate.
Thank you. Mr. Bailey.
Your Honor, Michael Bailey on behalf of Boris Epstein. I just wanted to mostly agree with Ms. Chapman's argument. I do believe the defendants themselves are entitled to copies of the transcripts with the grand jurors and accurate names included. There are a number of questions when you read through the transcript that can reflect anything from bias of a grand juror coming in, which is repeated in the transcript, to potential outside research that grand jurors were doing into additional resources that weren't being presented in evidence. And it's important, obviously, for the attorneys to be able to know what grand juror is asking this question, and if there's a common theme among one grand juror or 4 different grand jurors. But it's also the right of the defendant to know and to see the full transcript in their defense. And so I think it's perfectly appropriate for the court to limit the use in any public pleadings of the names of the grand jurors, but the defendants are entitled to see them.
Could the same goal be met if they were, each grand juror were assigned a number or a letter, and that way you know the frequency of grand juror 1 asking certain questions, or any inferences you can draw from grand juror 1, as opposed to just blocking it out entirely, and therefore you don't know whether every grand juror asked a question or whether it's one asking every question?
That would certainly be helpful, Your Honor, yes.
Okay, thank you. Anyone else want to join in?
Judge, Kurt Olson on behalf of Mr. Roman, we have joined, and I don't know if you want us to do this on the record too here, but we join in the arguments of each attorney. I just made, and obviously Mr. Roman is another one of those defendants who resides out of state.
And I am operating under the assumption that everyone has joined in this motion, whether it's been filed or not, because it seems to apply to everyone. I know there's different arguments for the defendants that reside out of state, but the substance of it is similar. So if you don't weigh in, I'm assuming that you have joined. So this argument is not waived on behalf of any defendant. Counsel.
Stephen Binhack for Tyler Boyer. Excuse me. Judge, I rise only to make the point that my office is actually out of state and my client is in state. So we have the inverse of the problem, that if I want to sit with my client, it even raises the issue, and I've been overly careful about not doing this to this point, of even sharing on Zoom, for instance, the document. So there's really, it's a very significant impediment for our preparation to not be able to allow our client to see the documents. Also, I suspect this is true with many of the other defendants in the case. My client travels pretty extensively for work, and you know, it's not easy to get a day to get together. So to allow him to have access to the documents in his home or in his office, obviously with the admonition that he can't share them with anyone, is a very important thing for our case. The other thing I would say is, I would not have a problem at all with giving Mr. Boyer, for his copy, a copy of the transcripts with the grand jurors' names redacted, and I would have no problem filing in any public filing without the name of the grand juror. But I think it's very important for my client and I to be able to discuss the names of the people. There may be some issue related to the person that he knows that we don't know, that some of the defendants know, that the lawyers don't know, that may be relevant to the motion that we may or may not make in the future. So I think it would be inappropriate to shield the discussion of the actual name, but the public airing is a different story, and we don't have a problem with that. Thank you, Judge.
Thank you. Anyone else? All right. Does the state have any final argument?
Thank you, Krista Wood, on behalf of the state. First, as it relates to Exhibit 5, there was a single slide that was inadvertently not included on the Exhibit 5 that was previously disclosed. There was also a flow chart that was previously not disclosed. I made an error and labeled the flow chart both things, and so I gave it twice. I now know that I made that error, and we are working to disclose the corrected Exhibit 5, and that should be disclosed this week. There was nothing untoward. I just made a mistake when I was labeling the documents.
I didn't hear any argument to suggest that this was nefarious on anyone's part, just that it was incomplete, so thank you.
As to the, first, as to procedure, the state has no objection to defense counsel communicating via Zoom or some electronic means with out-of-state or other defendants who are not able to physically be present with the defense counsel. Our concern was not having a physical copy with the defendants. Our concern is also with the names of the grand jurors, and there have been significant leaks. There were several news and media reports which gave very detailed information, and we have attempted to identify where those leaks came from, but we have no idea. And there were also subpoenas that were leaked, and they may not have been intentional leaks. There's an inadvertent leaks too. The point is that it's information that Arizona law recognizes as being anonymous and secret and private proceedings that have been made public for whatever reason. And the fact that there's 18 and now 16 defendants, it leads to a greater chance of even inadvertent disclosure, which could cause harm to the state grand jurors who were present. And obviously, our system depends on people appearing and being state grand jurors. And while Georgia is not Arizona, it is the same type of case. This is an issue that many people feel strongly about and has resulted in many types of harassing information as outlined in our indictment and as has been reported in our motions specifically to the Georgia grand jurors. Also, the attorneys will still have the opportunity to see the names of the grand jurors. They can still go to the court and identify those names and still make all the arguments that they feel are appropriate. And the defendants will still be able to review the substance and the exhibits and the grand jury transcripts. At the very least, if this court determines that the defendant should be able to have a copy, we would ask that those be redacted with the grand juror names and that they return those copies back to defense counsel.
The ones that were unredacted?
All of them. So we would ask still that the unredacted ones be returned, and if this court finds that the defendant should have a physical copy, we still argue that they should not have a physical copy. They're able to communicate virtually or online or via Zoom or some other electronic methods. But if this court does allow the defendants to have copies, we would just ask that they be returned.
The policy or legal considerations, let's say Mr. Lehman or Mr. Meadows had the grand jury transcript to review, what's the reasoning for requiring that it be returned after the review?
It's still a grand jury proceeding that's protected by Arizona law, and so the same concerns still apply. We are still asking this court not to allow the defendants to have a physical copy.
Okay. What, other than the grand jurors' names and identifying information, what else are you asking that would be redacted that they would have access to?
There's nothing else that's redacted.
Okay. I posed an idea about a way to see if there's any common thread among any of the questions that the grand jurors posed about giving them, doesn't matter what symbol or number or letter is assigned, but just to know that somebody could say, well, let me review all the comments grand juror 1 made versus grand juror 5. Would there be a problem in redacting it to put that designation so you know the same person asked different questions or they were different people?
We could do that. Yes, that is a possibility. It would just take us time to go through to be able to do that. There are approximately 20 days of testimony, but we could do that, yes.
I assume some time will be spent just redacting it. So when you do, the extra step would be identifying, instead of by name, what number they were.
Yes, they've already been redacted, so we could go through and try and identify and give them numbers associated with them.
All right. Thank you.
Thank you.
Have we covered everything there is to cover on the motion for protective order? Okay. Does that bring us then to the anti-SAP or anti-SLAP motion, or is there something to address before that one? Anyone?
Judge Nick Klingerman, I think we had two probably shorter motions first.
Okay.
Mr. Lehman's discovery motion, and then I think our discussion was to handle the 16-4 motion first.
That's fine.
Yeah.
The discovery motion was submitted as a list, defendant's list of discovery. So I want to just understand what the dispute is, and then I also read the state's response. So let's address it. This is the discovery issue raised by on behalf of Mr. Lehman.
Yes, Your Honor, the minute entry, Lacey Cooper, I'm sorry, Your Honor.
There you are.
The minute entry from the arraignment for Mr. Lehman had the commissioner specifically order us to provide a list of specific items of discovery that we hadn't at that point received. And so we complied with that minute entry, even though the court subsequently ordered this to be a complex case and obviously some wheels were in motion. Nevertheless, we went ahead and complied, and you'll see it is exactly that. It's just a list, more of a notice than a motion. It certainly previews, Your Honor, some of the discovery issues that I think are going to come up after the court hears the anti-SLAPP motion today. And if we receive a favorable ruling, we will definitely be pursuing some of these in a more formal motion. But this is exactly what it purports to be, Your Honor. So I don't know that we need further discussion of that at this point. And instead, I would say perhaps a different discovery conversation should be had after we hear the substantive motions.
Okay. So I'm going to treat it then, because the state's response to it said you're working on or have provided or will be providing some of the things that were on the list. Am I remembering that correctly?
I think that's fair. There are some things on the list we will provide, Your Honor.
Okay. So would it be acceptable then to treat it now as there's been an issue raised or identified that the parties are working on, and then once it's known where there's a dispute, the appropriate motion will be filed?
Yeah, I think that's correct, Your Honor. There were some items on the list that the state has refused to provide, which again relate directly to the anti-SLAPP motion. So I think Your Honor is correct that we now are at a point where we can file a discovery dispute motion.
Okay, very good then. So I'll note that in my ruling that everybody's on notice of what kinds of issues there are, and the specifics will be raised when appropriate.
Thank you.
Got it. Okay. Are there any of those more simple motions to address or less complex, I should say? All right. I'm going to have to ensure that our court reporter get a break soon, and I don't want to break into the arguments of anyone. I assume some of you it's a defense motion, and it's been joined by almost everybody. And you may, as you hear the arguments, decide that what you need to say has been said, or maybe you'll want to add. So I know there's a lot of people to hear from. Would it be appropriate to take a break now or get started? Break now. I'm getting on. All right. So why don't we take we'll reconvene at 10:35, and who is going to take the lead? Mr. Willenchuk has volunteered. All right, thank you.
You know, before we break, for those that are appearing, Mark Williams for Mr. Giuliani. For those that are appearing telephonically or remotely, may they be excused, or do you want them to?
I will leave, I'm glad you raised that. I'm going to leave it to counsel on the rest. We've done all the things that I would have required for any of the named defendants. I know that there may be an interest in remaining, and there's also a right to remain. But if any of you need to go about your day, just when we get back, if you could indicate that you're waiving your client's appearance when we reconvene. So I'll leave it to each of you individually for your respective clients.
But at this point, Your Honor, may those that are appearing telephonically be excused?
Yeah, as long as you're going to waive it when we get back.
Okay.
Then, so yes, Mr. Giuliani, Mr. Meadows, Mr. Montgomery, Mr. Lehman, Mr. Epstein, Mr. Roman, I think I've done the roll call there. Any of you that want to, with your attorney's agreement, thank you for joining us. I will expect you either here or virtually for the November proceeding. That's the next one that is scheduled. There will be things that I will need you to participate in or might, and then when we get further into it, we could deal with it like we are today, of whether we need you for the whole day. All right, thank you all. We'll take a break now.
Thank you, Your Honor.
Notice that you're doing depositions just in light of that conversation.